This is Rob Bovarnick from Bovarnick and Associates, and this is another in a series of legal tips for you. Today what we're going to be talking about are confidentiality agreements. Confidentiality agreements are something that can be used both in litigation and in transactions. And confidentiality agreements generally, that's exactly what it is. It's confidential. You're trying to keep something confidential. In the case of litigation, at the end of a case, when you settle the case, you may want to keep some or all of the terms confidential. Similarly, if you're engaged in a transaction, you may want part of the transaction to be confidential. So if you're going to do a confidentiality agreement, what is important? Should it be long? Should it be short? Are there certain terms you want to use? And while there's no one right answer, what I can tell you we do here is that we have a basic template or basic form that has certain things that we try to include in each one, and then we modify it to adapt to a particular situation. So I have in front of me is a portion of a settlement agreement, and it has the confidentiality provisions. And what I want to do is I'm going to go through the topics, and there are 11 or 12 of them that we have, and I'll go through them and explain what they are. The first one is just called confidential information, and it's a definition. It says what is confidential information in the context of the particular matter, and it's going to vary from case to case and transaction to transaction. So whatever is important in your situation, that's going to be the definition of confidential information. Next is we have a section called use. Under what circumstances can you use the confidential information, and under what circumstances are you prohibited from using the confidential information? Third, similar to use, is disclosure. Under what circumstances are you permitted to disclose the information? And normally, confidential information can be disclosed in one of two different ways. If what had been confidential becomes publicly known, then the confidential information loses the imprimatur of being confidential and is out in the general public, and it can be used by anybody. The other time that it can be used is if you are required in some type of a court or administrative proceeding to disclose that. And what sometimes you will do in that situation is you put a few other hurdles in there to say, well, before you disclose the confidential information, you will try everything you can to convince the court that it is not necessary that the information be disclosed. Next is something called non-circumvention, and that's pretty much what it sounds like, which is you can't do an end run around the confidential information. We're trying to keep this confidential for the benefit of both parties. Then there's always going to be some type of an exceptions situation, and that may be just what we said before relating to the courts, or when it gets into the public domain, or you may have other particular exceptions relating to your specific matter. And then there's a section called documents, and what that is, often if there have been documents exchanged, you may want to have a certain term pursuant to which the documents have to be returned to you at the end of some period of time, or perhaps destroyed, generally at the choice of the person who the confidential information is in the benefit of. Termination provision. Is this going to last forever? Is this going to last for a number of years? What is that going to be? Again, there's no one right answer. It depends on the facts and circumstances of your particular case. Normally, we have a few years while the information will remain confidential. Next is an important one. It's called injunctive relief. What happens if somebody breaches the confidentiality provisions? Now, obviously, if the other person breaches the confidentiality, you can go ahead and sue them. But the problem is that information is already out in the general public. So what you want the other side to agree to is that you can run into court and stop them. And you stop them by getting what's called an injunction or a temporary restraining order. And one of the things that you may want to include in your injunction provision is that if you have to seek injunctive relief from the court, that the other side, the offending party, has to go and pay your attorney's fees. So in a nutshell, those are the important provisions in a confidentiality agreement. I wish you luck in preparing yours. Thank you.